morning's docket. Case number 116640 in the matter of Jason Richard McDaniel.
Good morning.
Counsel, before you proceed, I don't see anyone approaching as Mr. McDaniel or representing him. Is that correct? Anybody in the courtroom here, Mr. McDaniel, or here to represent him? I see no response. Thank you, counsel. Please proceed.
Good morning. Penny Moylan appearing on behalf of the Disciplinary Administrator's Office. Mr. McDaniel, this is an original action in discipline. Mr. McDaniel was admitted to practice law in Kansas in 2008. His license was suspended in 2014 for failure to fulfill the CLE requirements and to pay the CLE fee. This complaint came to our office after it was discovered that Mr. McDaniel was practicing law while his license was suspended. He did that by defending a corporation that he was involved with in a civil action. And then upon additional investigation, we found that he also was appearing in 8 Shawnee County District Court cases. Mr. McDaniel refused to respond to any requests for information during the investigation, except for one email where he stated, an email was sent to him by our in-house investigator saying, "Will you please contact our office to discuss this?" And Mr. McDaniel replied by email saying, "I've chosen a different career path. I don't have time to accommodate Mr. Hazlitt in any way. If they want to simply suspend my license, that is fine for the time being. I am done practicing. I prefer not to receive any further communication." Subsequent to that, a formal complaint was filed. It was sent via certified mail that was unclaimed by Mr. McDaniel. It was also sent regular mail that was not returned to our office. An amended formal complaint was filed 5 days later, raising the Shawnee County cases. That was sent via regular mail and it was not returned to our office. The hearing was conducted. Mr. McDaniel did not appear at the hearing. He did not file an answer to the complaints. Evidence was presented to show service upon Mr. McDaniel, and we argued for a finding that the facts that were in the amended complaint were deemed stipulated. We also moved to admit the exhibits. The hearing panel did both. I argued for a finding of the following rule violations of 5.5, unauthorized practice of law, 8.1, failure to cooperate in a disciplinary proceeding, and 8.4, misconduct, basically conduct prejudicial to the administration of justice, and also a violation of Supreme Court Rule 207. At that point in time, I requested indefinite suspension. The hearing panel submitted its final report. It found violations of 5.5, 8.1, 8.4D, Supreme Court Rule 207, Supreme Court Rule 211 for failure to file the answer, and also Supreme Court Rule 218 for failure to notify the court opposing counsel and his clients of that he had been suspended. The hearing panel found the following aggravating factors: a pattern of misconduct, that Mr. McDaniel had repeatedly appeared in court while his license had been suspended, multiple rule violations, bad faith obstruction by failing to cooperate in the disciplinary process and failure to follow the rules of the disciplinary process. They also found that he refused to acknowledge his wrongful conduct by the email that he sent stating that he didn't want to accommodate Mr. Hazlitt. They also found that he had substantial practice in the law, that 6 to 8 years practice was enough to know that he needed to cooperate with us and also not practice law once his license was suspended. The only mitigating factor they found was no prior discipline. Citing to an Oregon case, In re Paulson, 346, Oregon 676, and ABA standards 7.1 and 8.1, the hearing panel recommended disbarment. I checked on the clerk's website, and it appears that citation was sent to Mr. McDaniel via certified mail and that he did accept service of that. A copy of the citation was also sent regular mail that was not returned to the clerk's office. In addition, the notice of hearing was sent to Mr. McDaniel via certified mail. That did return as unclaimed, but the copy of the notice of hearing that went to him regular mail was not returned to the clerk's office. I guess my recommendation today is to point this court to the case that I cited before the panel hearing for indefinite suspension, In re Barker 302, Kansas 156. And in that, this court said, when a respondent fails to appear before this court when facing recommendations of indefinite suspension, a sanction greater than that recommended by the disciplinary administrator or panel, even up to disbarment, may be warranted. Certainly, the lack of an appearance at a hearing before this court qualifies as an additional aggravator of these circumstances under consideration. So this morning, based upon this additional aggravating factor of not appearing before the court, it's the recommendation of our office that Mr. McDaniel be disbarred. We agree with the panel hearing's recommendation.
Do we have any questions? Any further presentation?
None.
All right. Thank you, counsel.
Thank you.